Welcome to Mohan's Teaching Corner. Today we are going to discuss about the law of evidence. Bharatiya Sakshya Adhiniyam, a comprehensive overview of the principles and rules governing how the facts are proved in courts, how different types of evidence are assessed in Indian legal system. So let us have some overview of Bharatiya Sakshya Adhiniyam. It is the replacement law, the core purpose and practical relevance. So replacement law, the Bharatiya Sakshya Adhiniyam, simply we can say BSA 2023, it replaces the colonial era Indian Evidence Act 1872 as a part of criminal law reforms. The core purpose teaches how facts are proved in courts and how different types of evidence are assessed for admissibility and relevance. Then practical relevance. So forms and bedrocks of courtroom practice, essential for litigation and trial advocacy, where procedural fairness and proofs are central. So the BSA, that is Bharatiya Sakshya Adhiniyam, works alongside the Bharatiya Nyaya Sanhita and Bharatiya Nagrik Suraksha Sanhita, BNS as well as BNSS, to modernize Indian's legal framework. So the core theme of Evidence Act. So relevance of facts, statements and testimony, documentary and electronic evidence, burden of proof, examination. So let us discuss one by one. Relevancy of facts. Facts in issues, facts forming part of the same transaction, motive, preparation and previous conduct. Statements and testimony, admissions, confessions, dying declarations and statement by persons who cannot be called as witness. Then it comes to the documentary and electronic evidence. So primary and secondary evidence, that is electronic records, presumptions as digital signature. Then burden of proof and examination, legal versus evidentiary burden, presumptions, examination of witnesses, privileged communications. So we'll discuss about the res gestea, that means things done. The Latin term res gestea means things done and is incorporated under section 4 of the BSA. It allows certain statements or acts to be admissible even if they don't fall under the direct facts in issue, provided they form part of the same transactions. So essential elements are: the fact must be connected to the main transaction, must be part of the same transaction in terms of time, place or continuity. Proximity in time, place is crucial but not sole determinant. Must not be afterthought or subsequent fabrications. Here, judicial interpretation. In Sukar versus State of AP, the Supreme Court held a statement made immediately after the incidents are admissible as a part of res gestea. So provided they are spontaneous without fabrications. So confession and co-accused. Section 24 of the BSC deals with the admissibility of confessions made by an accused person that also implicate co-accused. Key elements are: the confession must affect both the maker and the co-accused. The confession must be proved in accordance with the law. Both persons must be jointly tried for the same offense. So, the confession of a co-accused is not substantive evidence and cannot alone form the basis of conviction. It must be corroborated by independent evidence. Here, the judicial precedent in Kashmira Singh versus State of Madhya Pradesh, the Supreme Court held that the confession of a co-accused is weak type of evidence and cannot be sole basis of conviction. So here we are going to discuss one of the information that is called hostile witness. So what is the meaning of hostile witness? See, hostile witness is one who gives the testimony contrary to the legal interest of the party who called them. Section 157 of 1 of the BSA empower the parties to cross-examine their own witness if they turn hostile. So key features of hostile witness: a witness becomes hostile when they resile from their previous statement. The court must grant permission to treat as a witness as hostile. So the cross-examination by the calling party is permitted only after such declaration. Here the judicial observation we can say in Satpal versus Delhi administration, the court explained that a hostile witness is not necessarily discredited entirely and the court may be accept the parts of their testimony that are found credible. Here we are going to distinguish between customs versus evidence. So legal provision, section 11 of the BSA, that is a Bharatiya Sakshya Adhiniyam, recognizes custom as a source of evidence, particularly in civil disputes involving property, marriage, succession and religious practices. So conditions for the, let us discuss about the types of customs. General custom, it is prevailing throughout the country. Local custom, it is confined to a particular area or region. Family or caste custom, it is prevailing among the certain families or social groups. So conditions for the relevance, so the custom must be ancient and certain and responsible, must not be opposed to public policy or morality, must be continuously followed without any interruption, should not have been expressed, abolished by the statute. So conspiracy under Evidence Act, section 8 of the BSA makes acts and statement of one of the conspiratory relevant against others when a conspiracy is alleged. So conditions for applicability, there must be a prima facie case of conspiracy, the statement or act must be made during the continuance of the conspiracy, the act or statement must be reference to the common design. Here, the judicial interpretation in state of Maharashtra versus Dhamu, the court held that once the conspiracy is established, each conspirator is responsible for the acts of others in furtherance of the plan. This is about the conspiracy under Evidence Act, which is mentioned section 8 of the BSA. Then retracted confession. So let us discuss what is retracted confession. The definition: retracted confession is one where the accused initially confesses to a crime but later withdraws or denies the confession. So firstly he confesses the crime but later or withdraws due to some force, some political influence. That is called retracted confession. So the legal provisions for this particular retracted confession, section 22 and 23 of the BSA, that is Bharatiya Sakshya Adhiniyam, governs confessions, particularly those made to a or in the custody of police officers. So what is the judicial guidelines for the retracted confession? The court must verify if the confession was voluntary. It must be supported by independent corroborative evidence. If found to be trustworthy, it may be used for conviction. This is about the retracted confession, which is mentioned in the section 22 and 23 of the BSA. So here the judicial notice. What is the judicial notice? Let us discuss. So judicial notice is a rule under which a court recognizes certain facts as a true without requiring formal proof. Section 52 of the BSA empowers the courts to take the judicial notice of facts that are so well known or established that they need no evidence. So facts the court must judicially notice. So let us, the following facts are: laws in force in India, public acts of parliament, accession of signatory of treaties, the course of proceedings in Indian courts, the geographical divisions of India, government seals and official appointments, holidays. So these comes under judicial note. Then res judicata and prior judgment. So let us have what is res judicata and prior judgments. The definition: res judicata means a matter once decided cannot be reopened between the same parties, while CPC applies it procedurally, BSA applies it eventually. So the legal provisions are section 35 to 37 of the BSA deals with the relevance and admissibility of prior judgments in subsequent proceedings. So types of judgments: judgments in rem or relevant. Example: judgments on status, divorce, insolvency. Judgments not in rem are irrelevant except for a certain exceptions. So presumptions as a dowry death. Okay, so section 118 of the BSA incorporates the presumption that supports the prosecution in dowry death cases based on the circumstances of the woman's death within a specified time after marriage. So essentials to apply this presumption as a dowry death. The following are the essential to consider for the presumptions as a dowry death. The deceased was a woman. Death occurred within 7 years of marriage. Death was unnatural, like burns, bodily injury, etc. Woman was subject to cruelty or harassment of the husband or from the in-laws. The cruelty or harassment was in connection with the demand of dowry. So this is the presumption as to dowry death. So nature of presumption, it is rebutable presumption. The accused can rebut but by proving contrary evidence. Once the conditions are fulfilled, the burden shifts to the accused. So what is leading questions? It is mentioned in the section 146 of the BSA, defines the leading questions as those that suggest the answer which the person putting it wishes or expect to receive. Let me read once again. What is the leading questions? So section 146 of the BSA defines leading questions as those that suggest the answer which the person putting it wishes or expect to receive. So when it is permitted during the cross-examination, leading questions are generally allowed. During examination in chief and re-examination, so leading questions are not allowed unless the court permits them. They relevant to the introductory or undisputed matters. Example for the leading questions: you are present at the scene, were not you? He hit the victim with a stick, didn't he? So such type of questions called as leading questions. So what is dying declaration? The legal provisions 26A of the BSA makes a statement about the cause of death admissible as the exception to the hearsay rule. So essential for the dying declaration: essential, like the declarant is dead, the statement pertain to the cause or circumstance of the death, it must be voluntary, coherent and made in a fit state of mind, preferably recorded by the magistrate but not mandatory. So here the judicial interpretation for the dying declaration in Kushal Rao versus State of Bombay, the Supreme Court held that a truthful dying declaration can form the sole basis of conviction. So this is about the dying declaration. So if you want, you can take the screenshot of it and do subscribe my channel. Okay, then circumstantial evidence. Okay, the font is very little bit of small. You can zoom it the screen and you can have this particular PDF I'm going to post in the description. Okay, circumstantial evidence. So what is circumstantial evidence? We'll see. Circumstantial evidence refers to indirect evidence that suggests the occurrence of a fact through the inference. Section 4 to 9 of the DSC support the admissibility and relevance of such evidence. So the essential for the circumstantial evidence must be consistent with the guilty of the accused and must exclude every possible hypothesis except that of guilt, must form a complete chain of events. In this particular landmark case, we will see Sharad Bhardi Chand Sarda versus State of Maharashtra. The Supreme Court laid down live principles of circumstantial evidence, emphasizing that the chain must be complete with no other possible hypothesis. This is about the circumstantial evidence. It is the indirect evidence. Okay. Then types of presumptions: may presumption, shall presume, and conclusive proof. May presume means the court has discretion to presume a fact and shift to the burden to the opposite party to disprove it. These are reputable presumptions. So, shall presume. The court is bound to presume the fact unless it is disproved. There are mandatory but still rebutable presumptions. Conclusive proof. The court must accept the fact as proven without allowing any evidence to disprove it. These are irrefutable presumptions. So, types of presumptions are may presume, shall presume, conclusive proof. Example for the rebutable presumptions include possession of a stolen goods soon after the theft, section 119, and the dowry death within 7 years, there is a section 118. So, public and private documents. Let us discuss what is public documents and private documents. Public documents, as per the section 74 BSA, records of acts of sovereign authority, official bodies, tribunals, and public officers. Public records kept in any state of private documents. Example: birth and death registers, land revenue records, court judgments. So the private documents, it is mentioned in 74 subsection 1. All the documents which are not public documents called as private documents. Example: sale deeds, wills, personal correspondence. This comes under private documents. Then the mode of proof. Public documents can be proved certified copies. Section 77 BSA. Private document must be proved by primary or secondary evidence depending on availability. So, examinations of witnesses. Examination in chief. Section 142 BSA, conducted by the party who calls the witness. Purpose is to establish facts in support of party's case. Leading questions are not permitted unless the court allows them. This is about the examination in chief, Section 142. Then cross-examination, Section 142 of 2, conducted by the adverse party. Purpose is to test the accuracy, veracity and credibility of the witness. So leading questions are allowed, Section 146 BSA. So re-examination, Section 142 of Part 3. So conducted by the party who call the witness. Purpose is to clarify doubts or contradictions raised in cross-examination. Cannot introduce new material unless permitted by the court. So burden of proof we'll discuss. Definition we'll discuss in criminal cases, in civil cases. So the definition of burden of proof. Burden of proof is obligation to prove a fact in issue or a relevant fact. It can be a legal burden, that is obligation to prove the cases, or evidentiary burden, that is obligation to produce evidence. In criminal cases, in burden lies on the prosecution to prove guilt beyond the reasonable doubt. The accused is presumed innocent until proved guilty. Accused may raise defense like insanity. There is Section 105 BSA, but must prove it only by the preponderancy or of probability. In civil cases, the burden lies on the plaintiff to prove their cases by preponderance of evidence. Once prima facie case is established, the burden may shift to the defendant. So, key updates in Bharatiya Sakshya Adhiniyam. So, compared to the Indian Evidence Act 1872. It is a comparison between BSc and to the Evidence Act 1872. So, one is digitalization and electronic evidence. Section 61 to 66. It strengthens the recognition of electronic records, emails, SMS, metadata, CCTV, and cloud-based evidence with hash values and secure digital signatures. Then recognition of technological reality. So WhatsApp messages, blockchain based ledgers and digital contracts how explicitly treated as admissible evidence under the law. So it is a simplified structures and the language. So modern legal voluntarily replaces the British era language. So terms like may presume and shall presume are now clearly explained with the practical illustrations. So streamlined confession rules. So tighten the protection against the custodial confession unless it made before a magistrate or supported by discovery. That is CRPC Section 27. So BSA, that is Bharatiya Sakshya Adhiniyam, modernize India's evidence law, bringing in sync with the technological advancement while strengthening the fair and trial principles. So this is about the Bharatiya Sakshya Adhiniyams 2023. This is also called as Indian Evidence Act 1872. Thank you for watching my channel. Do subscribe and share with your friends. All the best for your coming examination.